Hi everyone. Today I just thought of explaining about anticipation. As we all know, for an invention to be patentable, it should be novel. Novel in the sense the idea should be new and it should not be disclosed into the public in a previous instance. So, anticipation, I would say, is a legal concept which will determine whether an invention is novel or not. But today I'm going to talk about a few exceptions to the anticipation. I would rather say a few instances which will not be render our invention anticipated. Exceptions are falling from section 29 to section 34. Before going through the exceptions, I'll just briefly try to cover the various causes of anticipation. Following are the 4 points that may cause anticipation. First one is publication. If the idea of our invention is previously published in some literatures, such literatures may kill novelty of our invention. Second one is prior claiming. If the similar idea or same idea of our invention is previously claimed by a previous patent application, it can also kill the novelty of our invention. Another one is public use or public knowledge. If the idea of our invention falls under public use or under public knowledge, it will also destroy the novelty of our invention. If such a instance occurs, we cannot patent our invention. Another one is traditional knowledge. If our invention is part of, if somebody could prove that if our invention is a traditional knowledge based invention, so it can also kill our novelty of our invention. Here I am going to brief the sections and subsections. 29.1 says, an invention claimed in a complete specification cannot be anticipated by an application filed before 1912 January 1. 29.2 subsection A. Disclosure made by a person without the consent of the inventor will not be considered as an anticipation. 29.2b says, in such a scenario, the inventor can make an application as soon as possible. So here, the safe thing which the inventor can do is make an application as soon as possible. 29.3 says, an application for a same invention is filed on a prior date by a person without the consent of the inventor will not be considered as an anticipation. Says, if the invention is communicated to the government in a previous instance, suppose, or a person authorized by the government. So such a disclosure will not be considered as like anticipation of the invention. Section 31A can be explained using a following scenario. Suppose the inventor exhibits or displays the invention in a particular exhibition, which is notified by the central government in the Gazette. Please note that if such exhibition is notified by the central government in the Gazette, the disclosure or the publication of the invention in that particular event will not be considered as an anticipation. One more point you have to note here that such a display of the invention should happen with the consent of the inventor. If these 2 points are meeting, such a display will not be considered as an anticipation. Section 31B. It is about the publication of some materials related to that invention in the exhibition. Such a scenario, like if some person publishes some materials related to that invention in the exhibition, in such a scenario also, that scenario won't be considered as an anticipation. 31C. Consider a scenario like another person, without the consent of the inventor, publicly displays the invention during the exhibition. If that happens also, it won't be considered as an anticipation to the invention. 31D says, if the inventor presents a paper, a technical paper, in front of a learned society. Learned society can be like a person who is having knowledge in the relevant field or something. Such a disclosure also will not be considered as an anticipation. For understanding the section 32, consider a scenario in which the inventor invented a big device. He wants to test it just to make sure that it will work satisfactorily. But the size of the device is too big. He cannot do the testing within an enclosed space. In that scenario, he have to go out in the public and test the device. So it is just for the just to test the efficacy or the efficiency of the device. Such reasonable trials will not be considered as anticipation. That is what this section 32 says. Section 33 simply says, if an inventor files a professional application about the invention and later he tests or publish the invention, such publication or invention will not be considered as an anticipation. Please note that the use and publication of the invention happened after the filing of the professional specification. In such a scenario, it will not be considered as like an anticipation. Section 34 is a reiteration of the sections 29, 30, 31, and 32. It simply means the scenarios that is being described in this section 29, 30, 31, and 32 won't constitute anticipation.